Thank you, Professor Adams. I also wish to acknowledge the traditional custodians on the land on which we meet today and to pay my respects to their elders, past and present. I also wish to acknowledge the very distinguished guests who are here today and to thank them for their attendance. And I also acknowledge the presence of Mr. Chris Puplik, both friend, colleague, but also someone who's worked in privacy for a long time and was, in fact, the very first Privacy Commissioner, who was instrumental in the introduction of New South Wales privacy legislation, the two pieces of legislation that I work under, amongst other reforms. So thank you. Now, my thanks also to Ahmet and the Affinity Foundation for the opportunity to speak today on this topic about which I am extremely passionate. Now, privacy means many and different things to individuals, to cultures and religions. And it's not going to be possible to address all of those issues, including the ones that Professor Adams mentioned, such as the ABS, the census, and social media. But in a world where anyone with a smartphone can become an overnight internet sensation simply by, with a click of a button, uploading an image which is out there for digital eternity, it's timely for us to consider just what it is that privacy means to us as individuals and as to a society as a whole. What is acceptable, what is not, and what can we do about it? I also do want to acknowledge the fact that there are differences in perceptions of privacy across generations. This is one of the issues which comes up very frequently, is that the young don't care about privacy. And I haughtily dispute that, both in terms of the literature, but also in terms of my own experience. There are differences. For older people, privacy tends to mean a lot more about the ability to control access to things about oneself or your decisions that you make. But for the younger generation, younger people tend to feel more private when information which is freely available, which they may or their peers might have uploaded on the internet, cannot actually be attributed specifically to him or to her. Now, a precise definition of privacy is elusive, but typically we would understand it to be a state in which one is not observed or observed by others, or in information privacy terms, where the individual is able to determine whether, when, how, and to whom information which, whether it's personal or health, is to be revealed. So I'm not going to try and define privacy. I think that we can spend a lot of time doing that, and it's not necessarily the most productive way to go. But I will just refer us to the statements, the Universal Declaration of Human Rights from 1948 and the International Covenant on Civil and Political Rights. Australia was instrumental in drafting of the 1948 Universal Declaration and was among those countries voting for its adoption. And also Australia has ratified many of the international human rights instruments, including the International Covenant on Civil and Political Rights in 1980. But my talk today is to address what is and what isn't happening in the privacy space. And so, simply because of the broadness of the topic, I will need to be selective. So I've thought about addressing this in terms of what is happening internationally with United Nations, some 68 years since we've had the UDHR, but also to look at what is happening here or not happening with inside New South Wales. Starting internationally, as a result of a number of pressures, including the revelations made by Edward Snowden, the concerted efforts of civil society organisations and concerned member countries, in July last year, 2015, the Human Rights Council established the first ever position of Special Rapporteur on the right to privacy. This establishment by the UN shows that privacy is anything but dead. Professor Joseph Kenatachi of Malta University was appointed last year as a Special Rapporteur on the right to privacy. He brings 33 years in privacy and related areas, including technology law, information law, and anthropology, to the role, having written on topics as challenging as privacy, technology law, and religions across cultures. And whilst that sounds quite a hard mix to put together, it's actually an extremely interesting article. His appointment is for 3 years, And he has the mandate too, and I'm summarising that mandate, which is quite substantial, to make recommendations to the Human Rights Council for privacy protection by identifying obstacles to the right to privacy, raise awareness of the importance of providing individuals whose right to privacy has been violated with access to effective remedy consistent with international rights obligations, to report on alleged violations, and to draw the attention of the Council and the United Nations High Commissioner for Human Rights to particularly serious violations. Recognising that Affinity seeks to nurture interfaith and intercultural learning and to help build personal relationships between people of diverse faiths and backgrounds, I make the point that privacy is also integral to many faiths and to many worshippers, whatever religion. Privacy is sometimes essential if they are to have the freedom of worship and to practice their faith safely. The Universal Islamic Declaration of Human Rights of 1981 has at Section 22 recognition of the right to privacy. The 1990 Cairo Declaration on Human Rights in Islam also includes the right to privacy. The right to privacy is also established in international conventions such as the UN Convention on the Rights of the Child and the UN Convention on the Rights of People with Disabilities. But just back to Professor Kanatachi and his role as Special Rapporteur. To progress his work, he's established 5 thematic priorities. First, the role of privacy in the development of the individual and society, security and surveillance and privacy, big data, data analytics and privacy, and please notice I'm saying and, not or, health, genetic privacy, and the use of personal information by commercial and private sectors. Now, each of these thematic task priorities is to be advanced by task forces in conjunction with the representatives of civil society. And these representatives have been working particularly hard and in a very collaborative manner now in terms of the protection of privacy. I do not have enough time to speak on individually each of those 5 priorities, but his first thematic priority is one that I think is extremely valuable and is both very interesting, and that's the importance of privacy to the development of the individual and to the development of society. A lot of times we focus upon privacy in terms of information and information that describes us, but it's that intrinsic nature to the development of the individual and to society that I think is particularly important about his work and the way that he speaks on privacy. Essentially, Professor Kanatachi's point is that the fullest development of the individual depends upon the enjoyment of human rights, and obviously privacy, and that society in turn is enriched by its citizens developing in a context and environment which recognises and respects human rights. Privacy, along with the right to freedom of expression and the freedom of access to information, is important to the development of the individual and, again, as I keep stressing, the development of society. And that's particularly important, I believe, in the digital age. The right to privacy and the right to self-expression are complementary rather than in competition. There are a number of writers on why privacy is important to the development of the individual, including obviously the UN Rapporteur, but also Lord Justice Leveson, who led the UK phone hacking inquiry. And you may recall that was when the allegations were made against News of the World reporters, who amongst others were accused of hacking mobile phones of celebrities, such as and also 2 of the murdered schoolgirl, Millie Dowling, to gain information for their stories. Lord Justice Leveson came to Australia in 2012, where I met him at a conference given by the University of Technology, Sydney. And he quite unequivocally states that there is public interest in personal privacy. It is not just a benefit to the individual. In his words, the existence of a private sphere is vital for human development. It is a space in which individuals are able to experiment with preferences and build personal relationships beyond public scrutiny and judgment. Violations of that private sphere prevent individuals from obtaining those benefits. And where there is, for example, public interest in law enforcement at the expense of individual privacy, he argues that even there, the balanced result would be a proportionate invasion of privacy, saying, violation of the private sphere must always be proportionate to any larger public interest being served. The element of control over one's personal life is never all or nothing, but a matter of an infinite number of degrees and decisions. Everyone is entitled to some private space, and always provided that there is no countervailing public interest in the exposure of that private space, for example, exposing crime or severe impropriety. There is public interest in preserving the private sphere. Just to keep us moving, one of these, I'm going to just move now to the priorities and the strategies of the Special Rapporteur on Privacy. And one of those strategies is to promote national and regional developments in privacy protection at a regional level. And Professor Kenatachi has been working closely with data protection and privacy commissioners, such as my role, worldwide to raise the standards for privacy generally. I will be working on the Big Data Task Force, which is being chaired by a colleague, the Victorian Privacy and Data Protection Commissioner, David Watts. New South Wales has a data analytics centre, and I support the use of data to achieve public benefits, as long as the privacy of the individual is respected and there is compliance with privacy protection laws. I supported, very strongly actually, the legislation that established the DAC, as we call it, because the data sharing legislation requires agencies only to share data in compliance with New South Wales privacy laws. So hence my interest in this particular task force. I'm also hopeful of ensuring that New South Wales has representation on what I believe is another very critical task force, and that is of the Health Task Force. Health is a very critical area because information there has a particular different nature. When you're, for example, about your DNA, it's not just information about yourself, but also about your siblings, your children, and your parents. And there's also a very strong interest from others to actually obtain that information for a variety of reasons, some of which is commercial orientated as well. Now, Joe Kenatachi, and he does prefer that to be called Joe, as Special Rapporteur, is bringing a renewed focus to privacy as an enabling right that facilitates the development of the individual, but also privacy's contribution to a democratic way of life. As I was mentioning over lunch, in a recent Skype teleconference I had with him, he posed the question to me, where is Australia on the privacy scoreboard relative to other countries when it does not have a constitutional provision for the right to privacy? It does not have a Bill of Rights that sets out a right to privacy, and it doesn't have a common law tort or a statute for legal remedy for serious invasions of privacy. This is a bit confronting because I'm actually very proud of the fact that New South Wales was the second jurisdiction internationally in 1975 when it introduced the privacy protection legislation, the Privacy Committee Act, and this is where Chris was originally very instrumental in taking that forward to our current legislation. So if I now turn to what's happening in terms of New South Wales in the privacy space. New South Wales privacy law has two acts, and they are somewhat of a mouthful: the Privacy and Personal Information Protection Act of 1998 and the Health Records and Information Privacy Act of 2002. They bring important privacy protections for New South Wales in certain circumstances. But I stress these are by no means comprehensive protections. My report last year on the operation of the PIPA Act, the Privacy and Personal Information Protection Act, identified matters that need to be addressed to better meet the needs and expectations of the community. And chief amongst these, the comprehensive and consistent coverage of the users of government services, services provided by non-government organisations, as well as those provided by state-owned corporations. Coverage is not consistent. We also need to be considering application to private individuals acting in their private, family or household capacity, as well as to employees who are not acting in their official capacity, with incursions into privacy. Relative to other states, the exemptions for police are very broad, so broad that the New South Wales Law Reform Commission has made comment upon that. Also, there is no explicit coverage of physical, spatial or territorial privacy, and there is only the ability to rely upon the reserved powers of the role of the Privacy Commissioner. And I do acknowledge that other legislation in New South Wales does have provisions relating to privacy. These can place restrictions on the use, collection and disclosure of personal information and range from surveillance laws, criminal law, child protection laws and health regulation through to laws relating to the release of images under road transport legislation. Certain issues relevant or connected to privacy are, of course, appropriately addressed through other legislation. For example, behaviour that is grossly offensive or criminal in nature. And the New South Wales Crimes Act of 1900 provides a range of offences that may be applicable to serious invasions of privacy. But criminal law fails to adequately provide comprehensive coverage for serious invasions of privacy in a cohesive fashion and to provide this relief in an easy and timely manner. While some protections and remedies may be in place, some privacy invasive actions are not captured. For example, there are gaps. Under the New South Wales Surveillance Devices Act of 2007, unauthorised audio recording without consent is a criminal offence. But video recording without consent is not. So existing law is piecemeal, with some actions that intrude upon privacy being allowed, others, equally intrusive, are not. And we have no overarching civil remedy for serious invasions of privacy. On this, in mid-2015, the Legislative Council of the New South Wales Parliament established an inquiry into remedies for serious invasions of privacy. Many in this audience also provided submissions to that inquiry. The terms of reference raise the adequacy of existing remedies and whether a statutory cause of action for serious invasions of privacy should be introduced. Now, at the time that inquiry was established, there were a number of high-profile reports about social media, surveillance technologies, revenge porn, the sexualisation of young people, and the misuse of individuals' personal information. The parliamentary inquiry heard evidence from individuals, academics, legal experts, media and arts representatives, as well as from privacy advocates. And many appearing before the inquiry expressed frustration at the continued lack of action despite the number and quality of reports recommending change. The inquiry brought down its report in March of this year and recommended unanimously that the New South Wales Government introduce a statutory cause of action for serious invasion of privacy using aspects of the model proposed by the Australian Law Reform Commission in its 2014 report. And in so doing, they took into account the fact that New South Wales was a state that would be acting rather than having a national approach, and it considered the whole sorts of other things about criminalisation options. It was a very comprehensive and considered set of recommendations. In response, just recently, the New South Wales Government announced that instead of a statutory cause of action for serious invasion of privacy, it will seek to criminalise revenge porn, that is, the distribution of intimate or sexually explicit images without consent. Obviously, all of us, and I, commend action to address such extremely offensive behaviour. But I also believe that in addition to that, there was a failure to accept the unanimous recommendations that it represents a missed opportunity, and one that would have met the expectations the community has about the right to remedies for serious invasions of their privacy. Consultation will start soon on the government's proposal for revenge porn, and the matters which we put out to public consultation include the definition of intimate images, how they are distributed, how they are shared, what penalties should imply, including the application of any legislation to minors and young people, and how those issues should actually be unfolded throughout the community. And I encourage you, those of you in the audience who are interested in this area, to provide input. But as commendable as this proposal is, it does not assist people such as Witness A to the parliamentary inquiry, who experienced a grievous invasion of her privacy in a place, a private health setting, where she should have had every expectation that her privacy would have been respected, and when she was alerted to the breach of her privacy, has found no recourse despite her very energetic and continued searches. Before this parliamentary inquiry was held, there had been a number of comprehensive reports from federal and state law reform commissions, in particular 2008, Australian Law Reform Commission report, For Your Information, Privacy Law and Practice, the 2009 New South Wales Law Reform Commission report, Invasion of Privacy, the 2010 Victorian Law Reform Commission report, Surveillance in Public Places, the 2013 South Australian Law Reform Institute report, preliminary report, A Statutory Tort for the Invasion of Privacy, and, as I was mentioning earlier, the 2014 Australia Law Reform Commission report, Serious Invasions of Privacy in the Digital Era. So there's been something like 8 reports in the last decade, and 2 alone in 2016, one from the New South Wales Parliament, and then the final report from the South Australian Law Reform Institute. All of these reports have supported the introduction of a statutory cause of action that would enable an individual whose privacy has been invaded to commence an action for remedy. And these are very significant and eminent institutions. Of course, there has been some variations amongst the models recommended or proposed by each Law Reform Commission. But I'd stress again, there has been strong consensus for creating legislation that would provide an adequate remedy for serious invasions of privacy. And this, too, I stress, there's been a balance here which does not obstruct the reporting of matters by the press. So the freedom of the press is an issue that's also been recognised, of matters of public interest. But despite this, Commonwealth and state governments have not acted on those recommendations. As the Honourable Michael Kirby said in May this year, a statutory approach would provide individuals with a simple and clear pathway to seek a remedy. It would provide certainty to individuals who are currently experiencing or have experienced invasions of their privacy, but do not have access to a remedy. We cannot rely, unfortunately, upon the development of common law for invasion of privacy, as it has been slow in its development. And whether this will fully develop has been described by the Australian Law Reform Commission as at best uncertain. I note that the New South Wales Opposition's Shadow Attorney General has given leave of notice of the intention to introduce a private member's bill to introduce a statutory cause of action inside New South Wales. So we may see further debate, if not action, around this very important issue. So in conclusion, I'd like to leave you with a set of statements based on the principles originally outlined by the Australian Law Reform Commission in its 2014 report on serious invasions of privacy in the digital era. These are that privacy is a human right worthy of legal protection. There is public interest in protecting privacy. Privacy enables other rights such as the freedom of expression and is a means to secure beneficial outcomes for society overall. Privacy protection, though, is a shared responsibility of individuals and organisations, as well as government and the Parliament. To my mind, privacy law should meet international standards, be adaptable to technological change, be clear, certain, coherent and consistent, be accessible to citizens irrespective of their financial status. But most of all, it should provide remedies for serious invasions of privacy. Thank you.